The next case then is Precision Mechanical versus Brown and Root.
Please the court. My name is Ed Kinberg, and I represent the appellant Precision Mechanical Inc. in this case against Brown and Root. With me is my assistant, Ms. Kimberly Sloan. I'd like to reserve 5 minutes for rebuttal.
Yes, sir.
This case is a case of first impression in the state of Florida. It's also a case that presents kind of a unique issue. The case arises from a motion by a third-party defendant for recovered fees under 57105, under the 1999 version of 57105, where the court lowered the standard from absence of any justiciable issue to knew or should have known. And that's really critical to understand. But first I want to address the issue.
Is your case based on the notice that was sent from your client that this case wasn't meritorious?
This case did not require the notice. It was the pre-notice statute. But the notice was sent anyway as a matter of comedy or politeness to the other side. But we did not require the notice. The notice statute came in after this case was filed. Does that answer your question, Your Honor?
Yes, sir.
Thank you. But we did provide the notice. So there's really, the first issue is an issue of standing. The second issue is what standard should be applied to the judge's denial of the motion. And one of the problems we have is that the trial court did not explain the basis in any way for his motion, for his denial of our motion for attorney's fees.
And did you file a motion for rehearing to ask the court to explain the reasoning for the denial of the fees so we know what the trial court's reasoning was and whether it was correct or incorrect? Do you have an obligation to do that if you're going to argue to us that the order doesn't set forth any basis? How are we supposed to interpret it?
I don't believe we have an obligation to request a rehearing. The judge
in which case, if there was any basis on which the trial court could get to that conclusion, we're stuck with it, right? Because we've got to assume that the judge got to it in the right way unless the reasoning is set forth and it shows that it was false.
I don't believe that's correct, Your Honor. And we've discussed that issue in our brief. When the record is unclear, I think this is a pure issue of law. You can go to it's a de novo standard of review. Is there standing to bring this action?
That's only if we focus on the standing. There's really two issues here, as I understand it. Was there standing? And if there was standing, did the trial court abuse its discretion in denying the attorney's fees, correct?
That's correct, Your Honor.
Unless we can see from the record that the trial court abused its discretion, we never really have to even address the standing issue, do we?
I think you can see from the record that the court did abuse its discretion, but it's really enough here, and then we discussed that issue in our brief also, that you can also look at the facts and circumstances of this case. This is not a factual dispute that was determined by the jury. This is a pure legal dispute, and there's really undisputed facts for the most part. We know that the school...
Were you entitled to a directed verdict?
No, we did not get a directed verdict. I believe we were entitled to one.
The trial court's denial of the directed verdict, isn't that sufficient to show that you didn't meet the 57105 standard?
No, it's not, and that's an interesting point, Your Honor. I'm glad you brought that up, because that's what I wanted to address today. It's not. And the reason it's not is you have to look at the change in standard between the old and the new standard. The old standard was non-justiciable issue of fact, that there was absolutely nothing that you could proceed forward to trial on. The new standard is that the party or their attorneys knew or should have known that their case was not supported by material facts.
Can you help me with this? And this is something I don't understand. There was litigation. There was a dispute about the construction project. There was testimony that the project was done poorly, had to be done over. There was a resolution they thought, and then there was litigation. Why isn't that a justiciable issue? Why isn't it evident to the parties that we disagree and we need the court to resolve it for us? Why doesn't that show that there was a meritorious issue before the court that should be defended, and that just because I lost doesn't mean I knew or should have known that it was a bad case?
Your question brings us exactly to the point, Your Honor.
Well, then help me with that,
The
because
statute changed, and you would be correct under the non-justiciable version of the statute, the pre-1999 version of the
well, tell me
statute.
about the new or should have
The new
known.
statute, though, on the new or should have known, creates a situation where the judge can say, well, there's enough here that I can let it go to a jury, but, and I'll let the jury determine whether or not this questionable defense is meritorious. But the new or should have known standard, what the court's trying to do is they're trying to put some responsibility back on us as attorneys to
Well,
do
that's
our case
fine,
when
but
it's
my
over.
point is, as an appellate court, unless the judge says in an order, here is evidence, for example, the notice, or your own expert said that there's nothing here, or that it's obvious there's nothing here, you've got enough to get past the DV, but you shouldn't have brought the case in the first place. How are we to know that the party bringing the action knew or should have known that it was not a good action to bring?
You have to look at a little bit into the facts of the case, Your Honor.
So
That's
now
why
we act as jurors?
No. You're making decisions of law, and some facts become so clear that they shouldn't be decisions of law. They don't rise, it doesn't rise to the level where it becomes a non-justiciable issue, which isn't required anymore. It's something that an experienced attorney in this business, in the construction business, or an attorney practicing construction law should know. And in this case, the key fact was that the school board, and this is undisputed evidence, the school board declared the system defective as a whole and demanded its replacement before they entered into that settlement agreement. That alone is enough. Now, with the school board's...
Wait a minute, but the settlement agreement made a difference between latent defects and others, right?
That's correct.
So everybody contemplated there might be a lawsuit later for certain kinds of damages, right?
For latent defects, yes.
And was that the theory on which this lawsuit was brought, that this was a latent defect?
Yes.
And explain to me your argument why there's not even a justiciable issue of fact about whether this was a latent defect.
Again, I want to pull you away from the use of the word justiciable, because the legislature intended for the courts to look at it a different way. They tended to look at the attorneys have an affirmative obligation to look at their cases and determine whether or not there's a material issue of fact.
The trial judge decided there was a material issue of fact about whether it was a latent defect by denying the directed verdict and allowing it to go to the jury, right?
He decided there was enough of a dispute. But one of the clear facts was that the school board had declared the system defective. In effect, the school board was taking this case back to trial to get a do-over. They didn't like their decision. Their argument with the judge, and it was a minimal, marginal argument, probably enough to get over the non-justiciable issue, enough to get over the directed verdict issue, but their argument is the leak we have now is different than the leak we had before.
Now, in the 8-day trial, did they present testimony to support that theory?
They presented testimony of continuing leaking after the settlement.
Did they present experts that said this is a different leak, a different problem than what we had before?
There were no experts presented at the trial, Your Honor, on either side.
Okay. Did they present lay testimony that this was a different leak or a different problem than they experienced before?
They presented lay testimony that they had put after the settlement occurred, or around the time the settlement occurred, they put a meter on the water line, and that meter showed continuous water loss. This is 2 years, a year and a half after the water system went into use. There were several, if you look at the record, I know you all read it very carefully from your questions, there were several spontaneous breaks that were big enough to have water coming up out of the ground. And that's the issue. Now, if the school board had not issued the letter, with a couple of letters, they had not issued the final letter, and that's the one I'm really looking at, that says, this system is defective, replace it, before the settlement, there may have been more of an argument. But there's enough, because what you're looking at here is not so much facts, but intent. So what the jury was asked to look at was when the school board sent that letter, did they intend to have the system replaced, or did they intend to reserve rights? Did they intend to reserve rights about this defect, and did the school board actually believe it was that they knew about the defect effectively? And if you notice, the motion that we served for 57-105, which was not required, was served very late into the case after we had done depositions and confirmed that many of the school board knew and had issued this letter and had their own the school board witnesses testify to that. And that's what you've got to look at. You know, egregious cases call for...
Well, here's the problem. What you're saying is it's a calculus, and the person bringing the lawsuit has to look at how good or bad the case is. And it might be a great case, it might be a mediumly great case, and it might be a poor case, but there's a scintilla of a chance we might win. Your argument is, as I understand it, that if it looks bad and you file it and you lose, then we get paid, even though they may have won. or possibly could have won, or even though a judge said you got enough to get to a jury. Is that your basic argument?
It's substantially the argument. It's a little different than that, Your Honor, because
Well, without input from the judge in an order or in a ruling or in a motion for rehearing where you articulate the reasons why the judge erred, how is it that we determine that the case should never have been tried when obviously there were witnesses on both sides, testimony, and an obvious leak, and a replacement of a system, etc.? How is it that we can say this case never should have been filed, let alone tried?
you have to look at the intent of the statute. The courts moved to a standard where lawyers are now expected to use some judgment. Supposed to look at a case and say, if I've got a latent defect on day 3, if I've got a defect I want to claim is latent on day 3, somewhere before day 3, on day 1 or day 2, is there anything to me to indicate, to tell me, not to indicate, to tell me that they knew of it? And in this case, there was something before day 3 that they knew about it. They clearly knew it because they had ordered its replacement. And in fact, they're trying to use the legal system to get a free do-over, and they're basically using a Brevard County jury hearing a case about a public body in Brevard County that got ripped off by this monster contractor, Brown and Root. You've got to remember this in the context of what was going on at the time, to try and get the jury to say, oh, well, we don't really care what the law is. We're going to go ahead and give out money. And keep in mind, Your Honor, that after an 8-day trial, it took the jury an hour to reach a verdict.
And if the jury had come back in favor of the school board, would that have been a sustainable verdict?
I don't believe it would have been. I do not believe it would have been.
But it was not subject to directed verdict.
That's correct.
Is there any case law under the new statute which indicates that in spite of getting past a directed verdict, a party can be tagged with attorney's fees?
There's a case law under the old statute that says that. That says if you get past summary judgment and justiciable, it's
Not summary judgment, directed verdict was the question. Is there any case out there under either the new or the old statute which says you can get past directed verdict, you can get to a jury, but if the jury comes back against you, you can get hit with 57105 fees?
I believe that the Pewter case said that. Pewter summary judgment.
Didn't that case involve a summary judgment, not a directed verdict?
Yeah,
Well, that's not the question then. That's not the question.
But it's the same. Yeah. Why do you give a directed verdict? Because there's absolutely no chance you can win. And you've got to remember the change.
Right, and if you don't give a directed verdict, that means there is some chance that you can win.
And that's where you have to look at the legislative intent in changing the statute from no justiciable issue, which means absolutely flat out nothing, to knew or should have known, where you might be able to make a case.
Who or should have known what?
Your case was not supported by material facts. There's no
Well,
engagement on
if it's enough facts to get to the jury, why isn't that supportable facts sufficient to avoid the statute?
Because the jury is really looking at almost more than an intent issue. What did the parties intend when they entered into that agreement? But that's not.
Well, are you saying that
The fact that
this...
there's- I'm sorry, Your Honor.
I interrupted you. I apologize. Go ahead. You had not responded. No, please answer the question.
I got off track, and that's okay.
I apologize. Does your theory only apply to civil cases involving contracts?
No, it would not apply only to civil cases involving contracts. It would apply to civil cases in general.
Personal injury cases?
I believe so.
So if a person, say there were two persons in an accident, two separate trials, same testimony, one got a 0 verdict, one got $1 million, you could go against the person with the $0 and say you owe me attorney's fees because you didn't win?
It would be a fact-specific case. In this case, if you have an issue as to what happened, two juries can find different answers. But in this case here, there was no dispute that the school board said before they settled, the system is defective, replace it. How can you say a system is defective and replace it and not know that the system is defective? And that's why I said earlier that I think this is a particularly egregious case, and this is the kind of case that the statute was designed for, where you've got enough stuff where you may be able to get over the minimal threshold and get it in front of a jury, but in reality what you have is a junk case. And that's what
So your theory, it sounds like you're saying under the new statute, if an attorney brings a marginal but winnable case and then loses it, they're subject to 57105 attorney's fees.
I think the new statute puts a tough burden on judges because
But no, I understand you to say that if you bring a marginal but winnable case and nonetheless lose it, you're subject to 57-105 attorney's fees just because it was an iffy case.
No, that's not what I'm saying.
Well, you're saying can have enough to go to a jury to pass directed verdict so that you could, the jury could come back. There's evidence that would support a jury verdict in favor of the school board in this case. You've admitted that. And yet, which means it's a potentially winnable case, even if it's marginal, and yet you're saying...
I don't believe I admitted there was evidence in favor of the school board. I believe what I said was the school board knew for an absolute fact that they had declared the system defective and said they had it thrown out. Thank you, Your Honor. In answer to your question, I don't think this is a marginal case. I think, as we all know, so many cases on summary judgment and directed verdict are reversed because there's a scintilla of evidence, something like that a jury could consider. But here we have an 8-day trial and a 1-hour jury verdict, and we have one crystal clear fact. The school board said this was defective, and said the product was defective. And it wouldn't matter whether it's a car, toy, or a water line. The school board said it was defective, said replace it, and then didn't like their decision and tries to reverse it. And they're basically going by on a jury nullification theory from my perspective, where how could a jury in Brevard County, a group of taxpayers, not nail somebody like Brown and Root, and in the end, our company. And let me wrap up on this. I know I'm a little
So is it your theory that there couldn't possibly have been any latent defect, and therefore the settlement agreement which excluded out latent defects was just a nullity because there never would be a latent defect they could ever litigate over?
A different issue, Your Honor. A latent defect is a defect you knew or could not have reasonably known at the time. If something else, there's hundreds and hundreds of pieces to the system. If a broiler had failed, if a cooler had failed, that would be a latent defect if there was something wrong with the system. But here we have a known defect. You've got to keep going back to the letter, and this is why I think this is an egregious case. You have to keep going back to the demand that the school board set to Brown and Root and to Precision. And one of the issues here is the third-party standing issue, which we haven't really addressed. But the logical consequence of a lawsuit against a prime contractor is a lawsuit against the subcontractor, because Brown and Root's really not responsible for it. My guys are responsible for it, and they're going through Brown and Root to get to my guys. Now, if they knew at the time they settled that the system was defective and had to be replaced, they knew that, and then they moved forward. And that's what 57-105 is specifically designed for, to keep this kind of stuff out
Well,
of
if
court.
the defendant knew it was a frivolous lawsuit, it was a waste of time to bring a third-party complaint against your client. They should have just defended it and never brought you guys in, and you guys never would have had any attorney's fees, right?
Well, because under the contract, we have a duty to indemnify them for damage to the school district, whether it's right or wrong. We have a duty to indemnify them. If they defended the case in good faith and lost without our participation.
But they wouldn't if it was frivolous, right? Your position is, in essence, there's no way they could lose it. And if there's no way they could lose it, let them go get 57-105 fees, and maybe they should never have third-party in the first place.
You know, one of the things I tell my clients when they come on a new case, Your Honor, is that a judge or jury, and I apologize if this sounds disrespectful, can pretty much do whatever they want, pretty much for whatever any reason they want. You have the concept of jury nullification. A lot of lawyers play that game. We're trying to get jury nullification. We're trying to get the jury to do something they shouldn't and see if we can just push it just a touch far enough so that a court of appeals won't overturn it. That's what was going on here. This was a jury nullification.
In the summary judgment, in the directed verdict, aren't those the mechanisms designed to take care of those cases?
They don't always work. As you know, most summary judgment motions are reversed, and a lot of directed verdicts are reversed. I'd like to go ahead and reserve the rest of my time if I could.
You've got, why don't I just say 2 minutes? That way it'll be even for you.
Thank you.
You're welcome.
May it please the court. My name is Penny Mays, and myself, along with Kristen Davis, are here on behalf of the School Board of Brevard County. The school board requests that this court affirm the trial court's order denying the motion for attorney's fees that the appellant put before the trial court. The trial court properly exercised its discretion when it applied Chapter 54.
Let me ask you, what evidence did you present to the jury in the 8-day trial that this defect was one that you could not have known about before the settlement?
Your Honor, I did not attend trial. I'm just here actually arguing the bill before you.
Yeah, but isn't that, I mean,
What I understand is that the way the settlement agreement was set up was that it dealt with defects that were in existence at the time the settlement agreement was signed. So anything that occurred...
and there was
after that-
clearly a ton of evidence that there was a defect in the
system
CD.
never officially...
Didn't I hear his answer?
Yeah.
I apologize.
The answer? What evidence did your client present?
Is that there were still issues with the system, that even though it at one point in time did meet the pressurized test as required, that the system did continually have leaks. We had data, as appellant did say, that was evidence of a continual leaking even after...
How is that a latent defect if it's a defect that your client knew about and it just continued after the settlement? They clearly knew about leaks before the settlement. They sent demand letters. They requested or demanded that the whole thing be replaced. If you're saying that all you presented at trial was evidence that those leaks continued after the settlement agreement, how is that
I'm
evidence?
afraid I misspoke, Your Honor. It's not just that those leaks that were in place at the time of the settlement agreement occurred, but that there were additional leaks after that, after the settlement agreement was entered. So it's not just, well, we had 5 leaks beforehand and those same 5 leaks continued, that we had those 5 leaks, but after we signed that settlement agreement, we had an extra 5. And that's wherein we were arguing that it was a latent defect.
Argument is made that this system never really worked well and that the school board knew it was not working, went into negotiations to get it resolved, those broke down, and in essence, they got someone else to do the system. So, but then they got this letter. You knew you had a problem. You knew that you thought we were responsible, and now you want us to come back after you let us off the hook. How do you address that?
I think a good example is like buying an as-is car with a little rider on the end. I'm buying the car as it is at this moment, but if there's anything else that pops up that I don't know about when I sign this agreement, and I know it sounds a little bit ironic because it's like it's playing both sides of the coin, but if there's something else that happens to that car that we didn't already know about, we reserve the right in the contract, which they agreed to, that they would be responsible for the latent defect. It'll be a different story if Kellogg Brown and Root decided that they did not agree to those.
Okay, let's take your car. Say you test drive the car and the gas line is leaking. You say, listen, you take it to your mechanic. Your mechanic says the whole gas line system is a mess. You need to replace the gas line system. You say, I'm willing to buy this car, but you got to replace the gas line system because it's a mess. My mechanic says so. It's leaking, and the dealer says no, but I'll give you money off. You can do it yourself. So you sign a contract that says, I'm willing to accept this car as is, and unless there are latent defects that I discover later. How can you come back a week later and say, oh, the gas line isn't working correctly? That's a problem. It's a latent defect.
And I would assume, Your Honor, under those facts, that I might be smart enough to accept it as is, as it pertains to that gas leak. And if anything else happens to the car, to the carburetor, to the muffler, that those things would be included. But it just so happens...
And how is your case different from that? What facts did you present that say that your case is different from that?
The facts that we presented are just as I stated before, that the leaks were additional to those ones that the school board had already known of. We did, in fact, know that the system was bad, and that's why we agreed to the settlement and ended up having to replace the entire system. But the leaks that came up were after the settlement agreement was signed. They weren't the same leaks, and like I said, I misspoke earlier. It wasn't a continuing of the same holes in the system, but additional leaks later on in other places in the system.
How should we address the court's rulings allowing the case to go to the jury, that is, especially the directed verdict? Where the court said that you've got enough to go to the jury. How do we factor that into whether or not fees are appropriate?
Your Honor, from what my understanding is of how the case law has gone thus far in Florida, and my understanding is that there's only been case law on 57041, is which I say that the court should look at imperative materia, since there is no case law directly in court for 57105. And that case law states that if you have a directed verdict granted against you, if you are the moving party, you are precluded from recovering attorney fees because there is some type of justiciable issue. And although appellant argues that the post-1999 amendments to 57105 does lessen the standard. It went from like having an overwhelming or absence of absolutely no justiciable issue, but as it is laid out, the fact that you do have disputed facts of material facts of what is actually a latent versus patent defect, or either disputed law, that still in essence is the definition of having a justiciable issue to go before a jury.
Do we know whether the trial judge denied fees because of the standing issue, or by exercising discretion on whether there was an issue here, or on both grounds?
Your Honor, we don't know because the trial judge didn't put in his order, but in actuality, it doesn't matter. Appellant argues that because the trial judge did not put in this information into his order, that it lacks a presumption of correctness, and then that's incorrect. The case that appellant cited to deals with a bench trial wherein the court actually decided to issue on taking. And in that particular case, the judge did not hear any witness testimony. The judge did not make any factual findings. But here we're dealing with motion practice. And in motion practice, it is common for attorneys to give briefs to the trial court and to just have oral argument. It is often common for courts to just make an overarching general statement as to what their order is.
Should we then require judges to be more precise, to give detailed reasoning as to why they denied the motion, either for a motion for retrial or why they granted a directed verdict? So that if there are potentially fees involved, we'll know?
Well, the thing about it is that an appellate court is supposed to review a trial court discretion when it comes to using 57105. This court decided in 2003 and 2005 that the only thing you guys have to look at is abuse of discretion.
Well, if in fact the trial judge exercised its discretion to deny the fees, if the trial court denied the fees on the legal ground that there wasn't standing, then there's no abuse of discretion to review. Then we've got to review it to know, right?
Right. Yes, Your Honor. But in that same instance, even if the court believes that it does have to look at whether or not appellant has standing to recover attorney fees under 57105, we submit that they do not. All the cases in Florida that deal with Chapter 57, Section 041, dealing with costs that are, as a matter of right, if you are to recover judgment, all those cases say, and they point out that if there is no claim nexus between the person who is seeking to recover attorney fees under 57105, and with that, I point to cases like Shivers v. Smith from the 4th DCA, where there we have a typical third-party defendant who went after the third-party plaintiff for attorney fees. There was actually a claim nexus there. We also have cases like Pooter, where Pooter was an architect. He sued the owner of a project he was working on and the contractor. They, in turn, countersued counterclaims against Pooter. Pooter was like, well, then I'm going to third-party in 4 subcontractors. Pooter won against the architect and the owner of the project, but he lost with respect to the 4 individual third-party claims he bought against subs. The court awarded the defendant, Pooter, 57105 fees from the defendant in its counterclaim. But it also awarded the 4 third-party defendants that Pooter actually bought into the action himself. They awarded him attorney fees against Pooter. And Pooter asked the court, I want you to make these defendants pay what I owe these 4 subcontractors. And the court said, we can't do that. You didn't have a claim there's no claim between those 4 third-party defendants and the original defendant now counterclaimant. We're not going to make someone have to pay attorney fees for a party to whom they did not bring into the action. Actually, the School Board of Brevard County feels as though PMI is entitled to attorney fees, but they're entitled to those attorney fees from Kellogg, Brown & Root. They are not.
I ask you to address the argument in the appellant's reply brief that since there's no indication as to why the trial judge did what he did, we should first address the legal issue. And if we determine that the third party is able to bring a claim for attorney's fees under 57105 against the original plaintiff, then we should remand it back to the trial court to make a discretionary determination. And maybe it already has, but if it has, then to give written reasons for why those fees should be denied. Will you address that argument that that's the way we should approach the case?
I submit that the Florida case law is clear, that even if the court does decide to find that there is entitlement, which we suggest that they're not, that the second part of the 57-105 test is also failed on behalf of PMI, that they, in fact, cannot prove, as the court has previously addressed, that there was absolutely that we knew or should have known that we had no material facts. The court felt that there was a motion for summary judgment, which they denied. Even though appellant argues that that was on the eve of trial, the court still felt that it was enough information that the jury should decide the issue of whether or not the issues that we were complaining of with the chilled water system were, in fact, latent or patent defects. And so I believe that overall, this court cannot find that PMI, it does meet the standing issues because of the other cases dealing with standing in relation to 57-041 of the Florida statute. If Your Honors have no other questions.
Thank you.
I'll give you 2 minutes, sir.
Thank you, sir. Well, thank you again for your attention to detail in this case. You've obviously studied the facts, and I think when you look at the facts, that the decision is clear and obvious. First, I want to answer Judge Lawson's question that he just asked, and that is, should you rule first on the standing issue and second on the actual finding, whether or not there's sufficient evidence, or should go back to the judge? And I think you should. This is an issue of first impression. There's only 2 other states that have considered it, and both states have ruled in favor of the third party being allowed to bring a cause of action. And in fact, when you look at our brief, some of our cases talk about that also, where there's actually people that have been sanctioned by the court with attorney's fees who are not even parties to the action. You have to look in part to the egregiousness of the behavior. In the Puter case, there's 2 Puter cases. The second one is 424-7-2-78. It's the same people involved, same group involved, different piece of the case. But that one was interesting because the third party tried to get out of attorney's fees by saying that the court's denial of a motion for summary judgment demonstrated there was a justiciable issue of fact. And in its findings, the court issued 5 findings, and it said in the 5th one, the trial court's denial of Raymond's motion for summary judgment is insufficient to demonstrate a justiciable issue of law or fact.
You cite a number of out-of-state cases. Did any of them involve cases where the case had gone to jury and come back with a verdict and then the fees were awarded?
I'd have to look at the cases again, Your Honor.
I don't think you did. And the problem I have is that it appears that under your theory, in a close case, the loser would then pay attorney's fees simply because the person or the entity lost. Is that what the legislature wanted, to punish people for bringing close cases?
No, and that's not what I'm saying either. In this case here, where the defect is crystal clear and known beforehand, the legislator didn't intend for people, for public or private citizens, to use the legal system basically to get free do-overs, try and redo it on a jury nullification kind of theory.
Well, I asked you if it applied only to contract cases, and you said it would apply to other types of cases, civil cases. So it's just not a contract do-over case. Isn't your theory applicable to any kind of civil case?
It's in any kind of do-over case. If you know or should have known that the material facts did not support your case, the criminal case you heard earlier, if they had known that there was a material wrong
example, yeah.
What the court's doing, what the legislature is doing, is putting a greater duty on lawyers to use their common sense, to use their knowledge as attorneys to call out those cases that do not belong in the court, to prevent people from trying to use jury nullification to get a free do-over.
Thank you, sir. You've exhausted your time plus the additional time.
Thank you, Your Honor.
Thank you. We'll take a break for about 10 to 15 minutes. We encourage the lawyers to join us in the lawyers' lounge. Thank you. Court stands in recess.